it is this order that has driven the petitioner to this court in the subject petition. The learned counsel appearing for the petitioner submits that the witnesses that are now sought to be recalled is for cross-examination and not for further cross-examination, as they have not been cross-examined at all. She would submit that it cannot, the offense may be heinous, but it cannot be a case where there is no cross-examination of the witnesses at all. He would seek grant of one opportunity to cross-examine the witnesses on the date fixed by the concerned court and would not by the concerned court. The learned additional SPP would HCGP, na? Learned HCGP would refute the submissions to contend that the trial is being dragged on one pretext or the other throughout, and in the offense, the offense being heinous and the facts being horrendous, the trial is required to be concluded expeditiously, but would admit the fact that these witnesses who are now sought to be recalled have not been cross-examined at all in the trial, owing to the folly of the counsel who had represented the accused in the trial, who did not cross-examine on the dates fixed for such cross-examination. I have given my source. The four narrated facts are not in dispute, as they are all a matter of record. The petitioner is accused number 2 who is said to have threatened the victim of any threatened to kill the victim of after the incident that has happened by the hands of accused number 1. Therefore, accused number 1 and 2 are charged of the offenses punishable and so and so. The facts are horrendous, the offenses are heinous. The petitioner, the accused, filed 2 applications before the concerned court and 2 applications for seeking recall of witnesses and did not avail of the opportunity. In the normal circumstance, repeated applications would not be entertained, as it would become an abuse of the process of the law. But in the fact circumstance that the petitioner has not cross-examined the witnesses at all, as would reveal from the records, I deem it appropriate to grant one opportunity to the petitioner, and the cross-examination of those witnesses shall be completed on the dates on which they are fixed by the concerned court. It is made with a rider that the petitioner shall not seek any adjournment for further cross-examination of any of the witnesses, and no other application of the kind that is now presented before this court shall be entertained by the concerned court. The offense, as observed here and above, the offense is of the year 2017. The offense is of rape and the ingredients of POXO, as also POXO and murder, as the child with whom the accused number 1 had forced sex dies. In such cases, if the trial is not completed within the time that is prescribed under the statutes,
1 year.
i.e. the POXO Act, 1 year, it would 1 year, it would become travesty. Therefore, I deem it appropriate to direct the concerned court to conclude the trial within 3 months from the date of receipt of the within 3 months after the cross-examination of the witnesses. How many witnesses are there?
9 witnesses.
9. The cross-examination of the witnesses shall happen on a day-to-day basis, i.e. 9 days from the date of its commencement, and no adjournment shall be granted to the counsel for the accused for cross-examination. If in the event the accused would not avail of the opportunity, it is open to the court to proceed further in the trial. This is the last straw, STRAW, of opportunity granted to the petitioner. Is ordered accordingly.
12.
Petitioner speech.
Immoral traffic.
3, 4, 5 of the
ITP A1 and A2.
thing. Nothing immaterial has been seized, my lord. And
What is seized?
cash of is 2,000 and swiping machine.
ಇದು ಸ್ಪಾನ ಅಥವಾ ಹೋಟೆಲ್?
Spa Manoj.
What did you see?
My lordship, in the victim have stated, my lord,
ಏನಂತ?
they are forced to
Force to what? ಸುಮ್ನೆ don't dub the victims also as doing that work. ಎಲ್ಲಿ ಇದು?
Indranagar, Bangalore.
161, huh? Where are the statements? But your 1 and 2, sir, difficult.
Owner and the manager.
Hmm?
Owner and the manager.
Of course, yes. They are the ones to be alleged.
Yeah, and this is sumoto complaint. My
Maybe.
lords, can you look into the Mahajar if 15/2 is complied with
15.2 is not mandatory,
of the ITP Act?
not mandatory. RAH Seguran, Supreme Court, 2017 8 not mandatory. Went from this court, which had held it to be mandatory, Supreme Court has reversed it. Huh? ಅದು ಓನರ್ ಅಂಡ್ ಮ್ಯಾನೇಜರ್, ಅದು ಗೊತ್ತು. But what did you find there? Nothing. 15,000 rupees cash swiping machine ಎಲ್ಲ ಕಡೆ ಇರುತ್ತೆ.
2,000 rupees.
2,000 rupees. ಆಯ್ತು, ಅದು ಎಲ್ಲ ಕಡೆ ಇರುತ್ತೆ. How did you impute? ಅದು ಬಿಟ್ಟು ಬೇರೆ ಏನು ಸೀಸ್ ಮಾಡಿದೀರಾ ನೋಡಿ. If there is any other seizure, tell me.
Tomorrow.
List tomorrow in the fresh matters list.
Please.
Because you have been searching every spa. Only if you find something, definitely you tell. Otherwise, you can't dub every spa as hubs of prostitution. And and thereby declaring those people who do that massage as prostitutes. Not correct. Unless you find something, yes. No problem. ಈ ಟೆಕ್ನಿಕಲ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಬಿಡಿ, 15.2, 13.2 ಇವೆಲ್ಲ ಇಲ್ಲ. Yes.
Please.
13.
My lord.
326.
Senior is little busy. Pass over.
No grounds. Difficult. Passed over to next Tuesday. Passed over by 1 week. Next Tuesday, in the fresh matters list. Next. List after 4 weeks, entry model subsisting shall continue. Vacating stack idira.
No, my lord, settlement talks are still going on, my lord. For the
Still going
respondent
on.
number 2 in this case.
All right, council, both the councils in unison would submit that the talks of settlement are afoot AFOT. Therefore, lest this matter after 4 weeks, entry model subsisting shall continue to the next date of hearing. Next. Yarilva? No representation, list after 2 weeks.
My lord, serial number 15, I appear for the,
ಏನ್ ಮತ್ತೆ?
my lord, he is for the
Huh?
R2 in the serial number 15, my lord.
15 ಅಲ್ಲ talks ಆಗ್ತಾ ಇರೋದು.
Please, my lord.
ನೀವು 14 ಗೆ ಹೇಳ್ಬಿಟ್ರೆ
I appear for 14, my lord.
ಮೇಡಮ್ 14 ಗೆ entry model entry model subsisting shall continue till the next list after 4 weeks. Entry model subsisting will continue till the next date of hearing. 15 ಅಲ್ಲಿ ಅದೇನು ಹೇಳಿದೆ afoot ಅದಕ್ಕೆ ಹಾಕಿ. Yes.
Much obliged.
ಅದ್ರಲ್ಲಿ entry model ಇದೆಯಾ ನೋಡಿ.
Please, my lord,
ಮೇಡಮ್
it is
ಇಲ್ಲಲ್ಲ?
ಇದೆ, ಇದೆ.
ಇದ್ರೆ ಕಂಟಿನ್ಯೂ. Yes. All right. Next. Post immediate 16, post immediately after service of notice upon the second respondent, entry model subsisting shall continue to the next date of hearing.
Lordship, intermediate is only for 5 and 6, 4 and 5, my lord. There is
ಅಷ್ಟೇ.
no allegation of,
No,
your lordship,
no, sir.
Properties
Let the
belongs to the-
complainant come.
this
Next.
property belongs to the petitioners, my lord, therefore, I request before this court.
Already ಆಗಿದೆ order. We'll consider after appearance. Let them appear.
Please,
Yes.
date maybe.
Post in admission ಅಂತ ಮಾಡಿ. Post in admission, post immediately in admission after the receipt of the notice. So on. Yes.
15.
ಇದು MMDR ನಾಳೆ
Forest Act.
ಫಾರೆಸ್ಟ್ ಆಕ್ಟ್ ಇದು.
Forest.
They use the forest to make road.
ಅಲ್ಲ
ಅದೇ ಮೈನಿಂಗ್ ಮಾಡಕ್ಕೋಸ್ಕರನೇ ಫಾರೆಸ್ಟ್ ಅಲ್ಲಿ ರೋಡ್ ಮಾಡ್ಕೊಂಡು ಹೋಗಿ ಮೈನಿಂಗ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಫಾರೆಸ್ಟ್ ನೋದಲ್ಲಿ.
ಎಸ್ ಸರ್,
But kindly go through the page number,
ಬಿಟ್ಬಿಡಿ ಆ ರೋಡ್ನ.
kindly go through page number 40 minutes.
I will go through anything. Now, if you have made roads in forest,
No.
leave it.
No, Minister, the land belongs to revenue only.
Revenue na.
Kindly go through
It
page-
does not belong to you anyway.
No.
Does it belong to you?
No, not like that.
Then, yes,
Because Minister, kindly go to page number 41, Minister.
file your objections.
ಗ್ರಾಮಸ್ಥರ ಉಪಯೋಗಕ್ಕಾಗಿ
Learned additional SPP seeks 2 weeks time to file statement of objections. List after 2 weeks. Next,
18? 18.
list after 2 weeks, interim order subsisting shall continue.
ಮ್ಯಾಟರ್ ಮೇಲೆ
ಯಾವ್ದಿದು?
Settlement
ಆಗಿದೆಯಾ?
complaint, my lords, he had received the site and got registered, my lords.
ಆಯ್ತು. ಎಲ್ಲಿದೆ sir?
ಮ್ಯಾಟರ್ ಮೇಲೆ ಐ ಮೇ ಅಪೋಸ್ ದರ್ ಸೆಟಲ್ಮೆಂಟ್.
ಹೌದಾ?
Yes,
Why?
because BDA land,
VDA land.
BDA land.
He is the complainant, my lords, he made the allegation. Now, my lords, he registered the sale.
ನೀವಿಬ್ರು VDA land ನ ಸೆಟಲ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ರ?
Alla, my lords, the complainant, the accused number one.
Accused and complainant
accused
settle a
the com-
land does not belong to them.
No, my lords, the
When?
land belongs to the accused number one.
Hmm.
My lords, the complainant, my lords.
ಆಯ್ತು, ಮೆರಿಟ್ಸ್ ಮೇಲೆ ತೀರ್ಮಾನ ಮಾಡ್ಬಿಡಿ. List after 2 weeks, interim order subsisting will continue.
But the interim order was granted because investigation was not done for 2 years.
2 ಅಲ್ಲ, even
5
more.
years.
5 years.
Therefore, my lord, I made a submission last time. DCP has passed an order now. Now, departmental inquiry has been initiated against the persons who are responsible for it.
Correct.
So therefore, my lord, the investigation may continue.
ಆಯ್ತು, let the